Second part of the Daily Report with me, George Maringa, and Rhoda Nyamai on sign language interpretation tonight. The second part focuses on the Supreme Bench Ouster, that is the Supreme Court President, who is also the Chief Justice of the Republic, Martha Koome, and the 6 judges of the Supreme Court who have a petition, who are facing a petition to the Judicial Service Commission for their removal. To further discuss this is Ishmael Nyaribo on the far right, an advocate and governance analyst, as well as Evans Ndong, a lawyer. Welcome, gentlemen, to the program.
Thank you, Judge.
Asante sana.
Brilliant. And I'll begin with you, Ishmael. The Constitution of Kenya, of course, provides for the removal of a senior judge and also for the Chief Justice, Article 168, and the articles that follow later. Of what importance, or how come this is coming, in 2025? Are you picking political instigation? Are you picking legal merit? Does it have any locus standi?
Thank you, Maringa, for this invitation, and we are meeting here now, yes. And it's really exciting to actually get you to host me, and it feels good. Mm-hmm. Now, about this question of judges, a judge to be removed, the major grounds will be things like if he misbehaves, mm-hmm. or she misbehaves, she misconducts herself. And when you talk about misbehaving and misconducting, that means things that are not, things that might bring disrepute to the High Court or to the Supreme Court, to the judiciary, mm-hmm. things that are related to corruption, things that are related to incompetence. Now, incompetence is something juicy for a lot of us, because what is incompetent? I mean, these judges do interviews in full glare of the media, and we see how they are being grilled. And when you look at people like Martha Koome, the Chief Justice, she's been an ardent advocate, practicing in private practice. You can say, moving NGOs before becoming a magistrate, then became a judge, then became a judge of the Court of Appeal. Mm-hmm. At what stage did she become incompetent, if you may ask? Mm-hmm. Has she developed some disease in the mind or in the brain? I mean, if not, then when do you say she's incompetent? So for me, the journey to try to besmirk the Chief Justice for the sake of creating that office vacant is actually much more than the issues of competence, than the issues. Probably you can say, is she independent? But I mean, that would be one ground. And so you look at so many other things. And again, George, in 2022, the Chief Justice gave a long judgment using quite unsavory and unpalatable statements along when she was reading the judgment in terms of hot air, describing a more young, vibrant lawyer as somebody who did not have her mind correctly when she was making her arguments before her. Mm-hmm. How come at that time there was nobody who complained that there was incompetence, that there was misconduct? It is coming 3 years after that judgment. So, yes, as you say, is it political? I think for me, actually, I would say that this is an affront to people's career, which have developed over the years. Mm-hmm. And to say the least, it borders on carelessness in terms of just attacking judicial officers because they differ with you on certain areas. Mm. When we talk about the competence of the judiciary and what is happening across the board, then we can say, yes, we want to change, and we can call for the purge. But just to vilify, bring about 5 or 6, 7 judges and say they should all be removed, we are creating a serious crisis in terms of if the Judicial Service Commission find there are grounds, and then It calls for the tribunal to be, established, and then the president establishes a tribunal, and then these judges go there, and they are actually removed. Then there will be a serious crisis.
We will come to the crisis, and you know what that pertains, because we've seen how this country has behaved in terms of even IBC alone has not been constituted. I mean, we do not want to imagine what would happen without the the Supreme Court judges. Ndong, what do you read from all this? The ouster, we've seen your activity on social media. You have defended the Supreme Court judges. But what are you reading further to what we are seeing on this ouster?
Well, I think, Maringa, first, I think I need to begin this conversation by simply saying that when you walk to any courtroom in this country, Maringa, you will notice that the design of the courts themselves, whether it's the Court of Appeal, whether it's a High Court, whether it's a Magistrate Court, is designed in such a manner that the judge or the judicial officer is always on a high pedestal. The place where the seat is raised, and the rest of us are down here. That, demonstrates something. It demonstrates the fact that the nature of the work of judicial officers is such that the law takes them to be on a higher pedestal. They are not caught up in the normal politics as we know it, of the day-to-day kind of activities that we have here. And they are not part of the disputants. They are not part of us. So they are taken as neutral arbiters on the higher end. And that informs why the Constitution saw it wise that the process of removal of a judge is very serious. And as my senior colleague said, that I think two things are important to point out. The timing of this is just very suspicious, okay? It's very suspicious because we have had issues with the Supreme Court. The Supreme Court has had so many challenges, and everybody who has studied the Supreme Court knows the amount of inconsistency that the Supreme Court has had in terms of its decision-making. But that alone cannot warrant, the removal of Supreme Court judges. The question that we need to ask at this point is, are the people carrying this narrative having compelling grounds for the removal of the judges? And if they don't have the compelling grounds for the removal of the entire bench of the Supreme Court, the question therefore is this a political move? And most likely, I can tell you without a doubt, Maringa, that you remember when Maraga was the Chief Justice.
Yes. Some
of these disputants praised Maraga up to the point when Maraga nullified the 2017 elections. After the nullification of the 2017 elections, Maraga became incompetent. And the narrative of Maraga being the most incompetent CJ in this country reigned until when Maraga left office. When, as my colleague has said, when the entire Supreme Court made the decision to uphold the 2022 elections, we heard how, everybody came out and say, we must protect judicial independence. Maringa, the point is this, that the nature of the work of the Supreme Court is such that the Supreme Court cannot be, everybody cannot love the Supreme Court. You remember the 2017 uproar after the nullification of the presidential election. One group of the political class was here telling us this is a group of Wakora. They called the judiciary Wakora Network. In 2022, when the Supreme Court upheld the decision, of the presidential elections, the very same people came out and told us we must protect judicial independence. Judiciary is the only arm that has remained in protecting our right as a people. Today, we are being told that 3 years or so, 4 years down the line of the CJ as being the CJ, the entire Supreme Court and the bench needs to go. And my problem is this. My problem is that when you look at the grievances of all the petitions that have been raised, none of those petitions raises a question on the conduct of the judges. They simply question the merit of their decisions. And that is where the problem begins.
And I think, you talk about merit, by the way, and then the independence of the judge. What is independence? Independence means you are working within the principles of law, legal principles when it comes to interpreting what is law and what is fair in the way in which the facts have been brought to you. And you could be unfair, by the way, if somebody else, some priest was sitting somewhere and judging how you are deciding the case. But according to the facts brought before you, are you fair? Fair means, are you giving each person the right to address you Are you giving everyone sufficient time to address you? So, but you asked a question, Maringa, and we should not lose sight of that. Is this politically instigated or otherwise? To be honest, I think it is hate campaign. Even before we go to politically instigated, it's just hate campaign. I mean, somebody tells you, you cannot come and address us in this court. And I believe that is one of the worst decisions the Supreme Court can ever make, to stop an advocate from appearing before it, because that is why we are sworn in. We are sworn in to practice. I think one judge or two can recuse themselves, can say, I cannot hear you, because for some reason. I mean, and you have to state the reasons, because one of the duties of a judge is to sit. When you agree to be, appointed as a judge, you must sit. Once the JSC has nominated you to the president and president, appoints you as a judge, you must sit. It is the duty you have. So in this particular, scenario, I think it is more of hate. And this is about professional jealous, I don't know whether I call it technical hate. Someone just dislikes you, and they become so much enraged. In Kisi, there is this frog, you call it ogoto. Ogoto is just something that in a vimba too, and then you feel so awkward about a person, and you use English and semantics now to describe that person. It is not true that all the judges are incompetent. Let's be honest. I mean, these are brilliant minds that we have praised for the longest time. When they were deciding the BBI, you did not call them incompetent. When they decided the 2022 general elections, you did not call them incompetent. Then they make a blunder. And this is, we call it judicial error. They have not judiciously treated Amin Nasir, for example. They have simply told him, we cannot hear you. They've in fact written a note. They did not even subject him to address them. So I think that is extremely wrong. But it is not the ground to say that the whole judiciary is therefore incompetent. And again, you will find that most of our colleagues who are arguing high voltage cases in the Supreme Court, they have their own personal interest, Maringa. I mean, we have to be, I wish for the sake of the upcoming lawyers, we need to distinguish between losing a case where revenue is concerned and determining that that judge who was hearing you is incompetent. I mean, there are very obvious judgments in the High Court, Court of Appeal, that, especially the High Court, you actually, and magistrates' courts, you find a judgment. When you read it, it does not make any sense to a basic English-trained student, Form 4. They would not make any sense. That, again, is a ground to remove a judge, because decisions must be sound and based on sound reasoning. Okay.
And Dong, do you think, even as you look at it, was hot air, wild goose chase the beginning of the problems of the Supreme Court bench?
I don't think so. I don't think so, because I'll give you two reasons. Number one, the two leading proponents of the process have accused each other before of bribing judges. They are on record, but they don't want us to say that. The two leading proponents of that campaign, Maringa, have openly accused each other that we know you have been bribing judges. And the other says, we know you have been bribing judges. If for any reason, I am not making any arguments, Maringa, I have never made any argument that the judiciary is without challenges. The judiciary is with challenges. I have criticized the Supreme Court consistently. Why? I'll give you two reasons. Number one, the Supreme Court has been so inconsistent in its decision making. The Supreme Court tells you this today, the Supreme Court wakes up tomorrow and tells you this is the position of the law, and the next day it tells you this is the position of the law. But my point of disagreement with the entire of this process, Maringa, is if we are reforming the judiciary, let us have an honest conversation that is not being hijacked by political interest. And this is why I have said many times that we must purge the purgers. The purgers don't want to be purged. People of questionable professional ethical conduct have come to lead the process. We are not saying this, the judiciary has no problem. We are not even saying the Supreme Court has no challenges. But we are saying that you cannot remove judges merely for the merit of their decisions. Errors, as my colleague have said, in judicial decision making, go through the normal appellate process for correction. And I know this becomes complicated for the Supreme Court, because if the Supreme Court had us, as they add in the Ahmed Nasir issue, where they told Ahmed Nasir, you are permanently barred plus your 20 associates. I've said it was wrong. I mean, the right to fair hearing is one of the most basic rights. And even if, in case Ahmed Nasir had undergone...
because even you can't hear his staff. I mean, what logic is that?
So assuming that he had vilified the court and the court was so enraged and he had undergone the entire process, what was the issue of barring the 20 associates? But I'm saying we cannot remove them merely because of that, because the High Court has also told us that the standard of incompetence, Maringa, as a ground of removal, you can't isolate one decision or one act of a judge and say, because of this single act of a judge, let us remove the judge for incompetence. You must have a series of line of mistakes of this judge that goes to their professional competence, and then say, from the totality of these decisions, we can then conclude that, this judge is corrupt or should be removed from office.
Okay.
Number two, and lastly, it is not conceivable, and I've argued this all the time, it is not conceivable that you can, through a blanket process, remove an entire Supreme Court bench. I think one of the mistakes that happened in these petitions that have been forwarded before the JSC is that they are not particularized at the mistake of each and every judge, Maringa. We have just been told that all the 7 judges of the Supreme Court should go. We are not being told what was the role of Justice Lenaola in this and this and this. We are not being told what was the role of Chief Justice Koome in this and this and this. We are not being told. We are just being told blanketly that, look, the judiciary is corrupt. We are being told blanketly, look, the entire Supreme Court, the common court of juris pesa. The point is that, Maringa, we may have mistakes with the judiciary, but judicial independence must be protected. 2 great jurists, the former Chief Justice, Felix Frankfurt, one of the U.S. Supreme Court judges, he actually made a very, very important argument, as well as the former Chief Justice of Israel, Aharon Barak. He made an argument that judicial independence, Maringa, is not a privilege of judges, but it is a right of the people. If, for instance, today we wake up and say that I can remove a High Court judge because they disagreed with me on the law, the question is, how far can we go? And who is to make that determination? Is JSC going every time a judge makes an erroneous decision? Is JSC going to interrogate that decision and say, you did not reach a favorable consideration as we thought or as you ought to have been? What is the yardstick? How far can we go, Maringa? There could be incompetent decisions. There could be blatantly incompetent decisions, as my colleague has said.
Yes.
But I've always said that the route cannot be to open the Pandora box of allowing JSC to review those decisions.
But we must thank the High Court, because the High Court temporarily stopped, that what appears to be interference of the Supreme Court judges going on, with their work. But I want to point out this. You cannot stop an employer from making an ordinary inquiry of what he's mandated to do under the Constitution. And I think this order will be lifted as soon as possible, so that the Judicial Service Commission can go forward and inquire. You see, Judicial Service Commission is the beginning of just an inquiry. So I think it is not lawful or constitutional, if I may say, to stop the JSC from actually exercising its daily work. They've got, if somebody brings a petition to them, they've got to listen. What is it? Then in case the JSC purports to find that these petitions have merit, then the High Court can come in and block the appointment of a tribunal. The reason being, the process of the JSC inquiring, you may actually find that they have always dismissed a lot of petitions because they don't have water. So, Maringa, now, what about what my brother here, Mr. Ndong, is arguing about? One judge says this and another one says this. The same bench in the Supreme Court today says this, and tomorrow it says the other thing. So what is the stop to this? In my view, I've always argued that this discretion and independence of the judiciary should be tamed by some form of serious rules, serious standards, which everybody should meet. So that it is not left to your discretion I mean, Kenya is so now educated. Many people know what they want in courts. And then they come there and you speak a language they don't understand, and then after that they tell you, they throw the file, they say, close. We should have strict rules. With the AI age, with the improved technology.
Social media.
We should, you see, people are always talking about accountability of the judiciary. How are these judges accountable? How does somebody come to you and say, my cows have been stolen, but you actually tell him your cows have not been stolen because you have not proved it. So we need to have a standard, and this happens in improved, in developed economies. You are sure that your judgment, like in the small claims court, if I give that example, within 60 days, you must deliver judgment. So if in the High Court you don't have such rules, you are left to stay with a case from 1994 to date. It is in court. What answers are you going to bring? And generations have died and others have been born who are magistrates who were born the other day in 1990 are now listening to a case which started in 1980 or 1994 for that matter. So I think strict rules of conduct by judicial officers should be included in the judges' code of conduct to allow, so that at least we can have what we call uniformity of jurisprudence.
And whereas judges cannot discuss their decisions once they have been made, and in the era of social media and the bashing, how does a judge defend themselves if there is such a situation whereas they don't have social media accounts, there is the Judicial Service Commission, there is the judiciary that speaks on their behalf because it is at the end of the day public interest and what they do. How does a judge, navigate this?
Maringa, I have written about this and I've said many times that judges speak through their pens. And that is why you'll notice that the leading proponents of this fight, or the so-called purge of the judiciary, have consistently used social media because they are aware, Maringa, that judges ordinarily don't have the opportunity to respond to them on social media. The judges speak through their decision, they speak through their judgment. But I think there is something more important about this era, or this era of the judiciary that we have. We have seen in the recent past, I think this is the first judiciary post-2010 where we have seen judges going on live TV shows, judges going on live radio shows and telling Kenyans what the judiciary is doing. But I think as far as defending themselves, unless a credible petition is presented before JSC, then that is when they are likely to defend themselves. I think it is wrong to then use social media to mount allegations. And another coin to this is that it also erodes public confidence in the judiciary, because if you make claims, for instance, and you see, Maringa, how this fight has been transmuting will amuse you, because it began by, we have evidence. There is bribery in the Supreme Court. We said, now, take that evidence to the JSC. Then, we have evidence JSC does not work. I mean, JSC protects judges. Now, when we waited for the petitions, and it was, we were promised thunder and hailstone, what came out was just the Supreme Court, you made this decision, you ought not to have interpreted the law this way, you ought not to have interpreted the law this way. So I think there is a deliberate tactic to use the social media to vilify judges, to ensure that, the public confidence in the judiciary is completely eroded. And I think I slightly disagree with my senior colleague when he says that the High Court ought not to have stayed the process of the JSC considering the complaints before it. In fact, to be particular, the High Court did not stop the manner of processing the complaints by JSC. We must first understand, the role of JSC is not an inquiry role. The Constitution is very clear. It talks about, considering the petition to see if it discloses a ground for removal. That is not an intense inquiry, because the role of an intense inquiry is with the tribunal. So they simply look at that. They simply look at this petition that has been brought before me or before us. Is it one that discloses a ground that is prima facie, on the face of it? Does it then disclose a ground that can warrant a process of forwarding it to the president for a tribunal to actually investigate the particular judicial officers? If it it finds that it does not disclose, it dismisses the petition. If it finds that it discloses, then it transmits it for a tribunal.
Okay.
But I understand where the JS is also coming from, because the High Court has told us, I mean, remember Justice Wasilwa went to the High Court, and one question that Justice Wasilwa wanted determined is whether the judiciary has capacity or mandate to even touch a complaint that is based on the merit of a decision, a judicial decision by a judicial officer. And what did the High Court tell us? The High Court told us, in the words of the court, that once the JSC looks at a petition and realizes that this petition is solely on the merit of a judicial decision, the JSC should drop it like a hot potato. I believe that is what they are doing.
Yeah.
So what I just wanted to say, Maringa, don't say that don't say that judges cannot have social media accounts. In fact, judges do have media accounts. Those who want to be on Facebook, Twitter, or whichever, or Trump's, I don't know, it's called True or.
No, but I didn't say they can't have. I said they can have, but I don't think they should use their social media accounts as a platform to defend themselves.
And even George actually said, I'm trying to correct him, that the issue here is the judge is is limited to what he can discuss. He cannot, I mean, it's not, how can you discuss your own, writing, and it's not a symposium where you are discussing, trying to qualify your own article. These judges cannot actually speak, like he correctly points out. But then, and I think the judiciary must wake up. The judiciary must employ competent spokespersons. There is no need, there is no reason why they cannot do that. The Supreme Court should have their own spokesperson, the Court of Appeal should have their own spokesperson, and the High Court should have their own spokesperson, just like magistrates should have their own spokesperson, probably through the Kenya Union of Judges and Magistrates or something like that. They should have somebody who is not necessarily a judge, but can come out there and explain basic explanation in terms of when there are, people on social media, blasted the judges and all that. There should be somebody, in my view, and I've suggested this somewhere, that there should be spokespersons for the judiciary. There is no reason why we cannot, because these guys, you are attacking them like they are some lost morons, like they don't have, they have teeth. It's a very brilliant minds. You see some judges actually bring out very interesting jokes on their own social media accounts, and that's allowed. I mean, it's free speech.
Yes.
But we should have the Court of Appeal, Supreme Court and High Court, and the magistracy having spokespersons, people who can come and say, the judgment has been misunderstood, this is not what the judge means, this is what the judge means, but if you are not satisfied, you can proceed to the appeal. On
the issue of, it's what I wanted to come in as you enter the home stretch, Ishmael, and you alluded to it earlier, the absence of a Supreme Court bench. Assuming that they would be, removed from office, what are we looking at? And with the delays that we've seen, that have, precedences have been set before, what would this mean?
Before I answer that question naively, the normal way, the real crafty approach by the proponents of trying to remove the Supreme Court is to create a vacuum. And I mean, people are looking for jobs. Others are looking to destabilize, the Supreme Court so that they can do a whole purge for the whole judiciary. And what we have forgotten is that we are all Kenyans and we come from the same mothers. There is nobody who's coming from the sky and he drops into the country. So the best way to do this, in my humble view, is to ensure that a problem that exists within maybe a certain courtroom or a certain judge is dealt with according to that problem. But in terms of if all judges were to be removed, of course, Maringa, that that will present a constitutional crisis, and it may take the longest time to resolve it. And I don't know who it benefits. You have seen how the IBC took the longest time to fix. And I don't know who benefits from that. But I think we should avoid this cartel type of mentality of trying to deal with colleagues who are in the bench just because we are jealous and we are building up some hate. And of course, nowadays, hate is justified in several ways. But I think that is not correct in our country. So that constitutional crisis should not be allowed to, in fact, the head of state and Raila Odinga must ensure that they do not destabilize everything at the same time. If we have a problem in the IBC, we have a political instability where people are feeling hungry, economic instability, and then you now come up and say, now we can destabilize the Supreme Court as well and the judiciary as a whole. I think that is killing the country. We should not head that way.
Okay. And you, Ndong?
I think it should be very clear. It should be very clear. There are very exceptional circumstances within our constitutional architecture. First, if you look at the provision of Article 167(4), it is one instance that it presupposes that there can come a time when there are 8 judges on the bench of the Supreme Court. That is, the term of a CJ is about 10 years. If they decide to, their term ends before they reach retirement and they're still on the bench, we are likely to end up with 8 judges. So it is the only exceptional circumstance that the Constitution contemplated. But the Constitution of Kenya did not contemplate an entire scenario where the entire bench of the Supreme Court is not there, and for that matter, or even the Court of Appeal, or even removal of all the High Court judges. But for the Supreme Court is more fundamental, because if you look at 168.5, if a judge is removed by dint of JSC, like we saw with Justice Chitembwe, they then move to the Supreme Court to appeal that decision of the tribunal. Now, what happens when you remove the very Supreme Court to which an appeal is supposed to lie, in totality?
Yeah.
What happens? It means that the removed judges will not have, an avenue for an appeal. I think we have talked about this, and the proponents keep telling us that those are hypothetical and theoretical scenarios that we will deal with when we get there. They tell us in 2016, 2017, the Supreme Court did not have quorum for some time when Justice Rawal, the term ended, CJ Mutunga retired, and then Justice Tunoi was removed. And they say the Supreme Court operated with 4 judges for a while. I think, Maringa, we are not like Canada. In other jurisdictions, what then happens when the Supreme Court at any moment does not have quorum, or there is a likelihood that the entire bench is removed, they have a provision where they then appoint ad hoc benches, temporary benches of those who qualified to be sitting on the Supreme Court as the removed, or the ones that have lacked quorum. They do that in Canada and all the other jurisdictions. Today, we don't have such a provision. We don't have a constitutional court that is way above the Supreme Court. We only have the Supreme Court as an apex court. That leads me to a conclusion that whereas it is possible to remove all the Supreme Court judges, I think the Constitution of Kenya 2010 did not perceive a scenario where we have all the judges removed, or in fact, more than 2 of the judges removed, because then the Supreme Court will lack quorum. Yes.
Ishmael, what do you think is the precedence being set, and perhaps how can it be cured or corrected?
You mean in the removal?
Yeah, in the removal, yes.
It's a bad precedent. It's, we are showing very bad manners, actually, to purport to remove all judges just because of, like I said, there is no other explanation I can see except hate. This is basically hate, and this is actually just propaganda that a few of our colleagues are picking up to try and remove the judges, and it's a very bad situation. If it were to happen, that would be the worst precedent. What message are we sending to youngsters who are coming up to practice? What message are we sending to our colleagues in the bench? Can we not have people practice their careers in the right way, and where somebody does not perform correctly, can that person not be dealt with as an individual? We conduct very extensive interviews for judges to be appointed and magistrates. What do you call that? Is it that there's a cartel that wants to bring people to the judiciary and there's another cartel that wants to remove them? Why are we following this trend? Why can't we have qualified people do interviews and let us save them, let them work until they have exhibited complete incompetence and misbehavior, then we remove them. And we have to go for that particular individual, not to bring this kind of mudslinging into the bench.
And you, Ndong, as you wind up?
It must be clear from my perspective that I am not in any way making an argument of a complete immune judiciary. I have never, I will never. My argument has always been, if Justice Chitembwe was removed, if Justice Tunoi exited, if Justice Baraza, the DCJ, exited the judiciary, if Justice Gitumbi was removed by this same Judicial Service Commission, then it is possible when a compelling and credible case has been brought against any judicial officer of gross misconduct that does not touch the merit of their decision making to be removed. So let us purge the judiciary, let us reform it or whatever term, but let us not reform it through propaganda, through political witch hunt. We can only do it through credible evidence. Our judiciary has so far remains the bastion of justice. When all other arms of government have dropped the ball, it is only the judiciary that has stood in defense. During BBI, it is the judiciary that stood in defense. A number of decisions of the National Assembly has been put on hold by the judiciary. So the judiciary has remained the so far credible bastion arm of the government in terms of justice. We cannot destroy, and I've said it many times, we cannot reform the judiciary by destruction of its very foundational pillars like judicial independence.
Indeed. Evans Ndong, a lawyer, and Ishmael Nyeribo, an advocate and governance analyst. Thank you so much, gentlemen, for joining us on the Daily Report tonight. My name is George Maringa. On sign language interpretation has been Rhoda Nyamai. As always, stay safe and be kind to one another. I'll see you next time when I see you.